Okay, I think we'll kick off and get going here. Welcome everybody to today's webinar and session where we're going to be talking about estate planning for Americans living in the UK, and perhaps also slip in some top tips as we go along. First of all, just to start off with our disclaimers and risk warnings here. You'll be pleased to know that this recording is going to be available to you to watch back at a later stage so you can see your best bits. But please note that everything that we talk about during this session is for informational purposes only. It's not to be taken as personal advice. And also please do note that obviously investments are a risk and can go down as well as up. If you do want personal advice following this session, obviously contact any of the speakers that are here today. We will be going through our session today in a kind of discussion format between myself and the other panelists, but please do see the Q&A section at the bottom of your screen or the side, depending on your setup, and pop your questions in there. We'll try and answer some perhaps as we go along, or have a Q&A session at the end. The agenda for today, we will first off just kind of give you a bit of a recap on what the situation is for US estate planning considerations, give you a recap on what the UK considerations are here, and then introduce, for those who are not familiar with it, the concept of domicile and residence, and perhaps the difference between the two. To try and then bring this topic to life, we will go into a case study session where we'll share some details with you about a fictional family, and we'll have a discussion between us about the types of things that need to be considered, discussed, or looked into further, especially when considering one's estate planning. So without further ado, we will go into our first slide here, and I'll ask Brian to talk us through.
Perfect. Thanks so much, Nathan. And good to see you, James. So U.S. estate tax consideration is a little bit easier from the vantage point of sizes and scopes, because the exemption limits have been going up since 2000. We're up to $12.92 million of exemptions per person, which essentially means that if you have a married couple, you could get an exemption limit of $25.84 million. Now, if you're underneath that exclusion limit, you should take into consideration a few factors. One of them is that that limit is going to expire on a sunset clause in 2026, January 1st of 2026. So if Congress does nothing, we would expect that that limit will go down to $5 million, but that will probably be adjusted for inflation. So that amount would probably be between $6 or $7 million per person. The question we really don't know the answer to is whether gifts that are made from now until then for people that are between, say, $7 and $12 million will account for that $12.92 million exemption limit, or the $7 million exhibit, because gift taxes and estate taxes are lumped into one lump sum. So in other words, if you make $1 million gift to someone, you don't have to pay tax on the US side. You only lose the exclusion on your estate taxes for that limit. So this is a topic that a lot of people are discussing. Some people think it will be grandfathered in, but it gives the ability to pre-plan for that next phase in 2026 and those lower potential limits. Now, the UK side starts a lot earlier, so I'll pass it back over to Nathan to talk about that UK side and some of the considerations you might want to take into account.
Yes, I'm afraid the UK is not quite as generous on those allowances for individuals. The kind of nil rate band where you have a zero rate of inheritance tax applied is only £325,000 per person. So extremely low in compared to the generous allowances that Brian's just spoken about there. Now, there is an additional allowance, which is called the residence nil rate band allowance. That's up to another £175,000 per person. So theoretically, you could have up to £500,000 per person, or £1 million for a couple. Importantly, though, that residence nil rate band it can be tapered away, i.e., reduced all the way down to zero, if one's estate value is over 2 million. The higher you go over 2 million, the quicker you lose that allowance. I'm not going into the full details of the residence nil rate band because it is slightly complicated, but something to be mindful of if you are around that 2 million threshold to look at the details there. Now, slightly different to the US estate tax situation is that inheritance tax is a bit more flexible when it comes to looking back at previous gifts. We do have some small gift allowances where you can gift things like £3,000 per year, or gifts on marriage, or perhaps even gifts out of excess income that you are earning. And these will never be considered as part of your estate from an inheritance tax position. We also have something that we call the 7-year rule, i.e. gifts that you have made outside of those allowances. If you have made them 7 years before death, they are also excluded from your inheritance tax considerations. There are also particular assets that might be excluded from having inheritance tax applied to them, perhaps pensions or other business relief assets. And of course, there can be considerations of gifting into trust. However, such gifts into trust may trigger an immediate inheritance tax charge, so do need considering from that point of view. Now, important to mention a similarity is that the inheritance tax charge or the estate charge can be up to 40%. So this is not an insignificant tax here. It is something that is quite meaningful and on the entire value of the assets over and above the allowances that we have just discussed. Now, of course, whether US estate tax or UK inheritance tax is applicable depends on a range of different things, perhaps citizenship, perhaps residence, perhaps the location of your assets, perhaps your domicile, and perhaps we'll ask James to explain why.
Thanks, Nathan. So, yes, from a UK perspective, when we look at tax and the taxes that Nathan's just outlined, there are two key concepts that we are interested in. One is your resident status, which lots of people are very familiar with, given that we now have a statutory residence test here. But the other concept is domicile. And very often when I speak to clients, people get very confused around what domicile actually means. So in the UK, we have a particular view on domicile. It isn't just where you are resident. Everybody acquires what we call a domicile of origin when you were born. And assuming your parents were married at that particular point in time, you acquire it from your father. Failing that, you acquire it from your mother. And you keep that domicile of origin as your default domicile. It is very sticky. You can acquire later on, after the age of 16, a domicile of choice. And to acquire a domicile of choice, you've got to be resident in a different jurisdiction under their rules. But you've also got to have an intention to remain in that jurisdiction permanently or indefinitely. And this is where we run into trouble, because you might then say, well, how on earth do I show that I'm intending to remain here permanently or indefinitely? How is that judged? In effect, when the revenue look at this, they will look at every single aspect of your life. Where are you spending your time? Where are your assets? Where are your family? Where are your friends? What are your charitable interests? What do you do in the local community? And they look at all of these things in the round to see to what extent your actions will match the domicile position that very often your executors, but certainly in lifetime, you are taking. It is fraught with difficulty. There are plenty of cases where someone has claimed to be non-domiciled in the UK, but that has been rejected by the revenue because the actions haven't quite met, in their view, the relevant level. So domicile is one of those issues that occupies our time quite a lot as lawyers, and is absolutely crucial to get right early on. Your resident status very much dictates, as a starter for 10, your liability to UK income tax and capital gains tax. Your domicile typically it covers your liability to inheritance tax. But as I'm sure many of you have seen in the news and politically, if you are non-domiciled here, there are some serious tax advantages under the UK tax system that you can take advantage of, and those are really quite significant. So it is quite a politically charged topic, as well as quite crucial from a tax perspective. But the two concepts, domicile and residence, must be looked at in tandem when we're looking at the UK position, particularly where we're dealing with clients after cross-border advice. So
James, just on that before we move on that chart, you could quite easily have somebody who's, I guess, residence in one place, domiciled in another place, citizen in another place. How does this all get worked out?
And you absolutely can. And it's a question initially of looking at your position in each jurisdiction where it's relevant. So you'll see on the chart there, for example, from a US perspective, it's a citizenship-based system. So, you know, it doesn't matter where you're living in the world, residency is irrelevant, your domicile in some ways irrelevant, but if you're a US citizen, you are going to be liable to US tax wherever you are living. The UK, we work back down that chart, is a little bit different in that some of it is residency-based. Capital gains tax and income tax position is often residency-based, but equally your domicile can affect that. So it's a question of getting the advice in the UK and testing what your domicile position is looking like before taking any further steps, and being very clear, particularly where you might have assets in lots of different jurisdictions, or you might spend time in different jurisdictions, what your tax status is in each of those jurisdictions. Over the top of all of that, of course, you then look at overlaying double tax treaties and how those work. But let's leave that one for a moment, those overlay on the top, but we won't dig too far into the detail on that for the moment.
Thank you.
So we thought it might be easier to talk about this topic via a case study, so we can actually hang some things around it. Now, this, as you might imagine, has lots of different issues within it. However, it is not too far off a common situation for a lot of clients that I see, and I know Nathan and Brian, you also see as well. So it's not as contrived as you might think, but there are lots of things here to think about. So we've been approached by Peter and Claire. They're married and they have two young children under 18. Claire was born in New York and is a US citizen. Peter's born in the UK, moved to New York for work purposes after he finished university, met Claire, they got married, and they moved back to the UK in 2013, given that Peter's parents require a bit more care and looking after. They are looking to purchase a family home in the UK, which they jointly own, and that's near Peter's parents, but they're looking to move in the next few years. They've got an investment portfolio in the UK and a second property which is let out to a third party for which they're receiving rent. And in the US, they've sold their house in New York, but have retained portfolio investments. So that is the background we're faced with. So in the context of advising the clients, there are a number of things here that we've got to think about. Now, we've been quite vague as to whether Peter and Claire are coming to us at this stage. Ideally, they might have come to us before they moved back Far too often I see clients who've come to the UK and they're looking for planning opportunities, and unfortunately, once you're here, some doors are very much closed to you. So the ideal client really is one where we can have a chat with them before they get here. But in this case, they've already moved back. The first thing really we need to be very clear about is Claire and Peter's tax profiles between them. Now, clearly they're living in the UK. I think it's probably safe to say at this stage that they are going to be deemed to be tax resident here under the statutory residence test. There's nothing in this fact pattern that would suggest otherwise. The more interesting question is domicile. So Claire being born in New York and a US citizen, we would need to find out a little bit more and dig a little bit further, but on the face of it, it is quite possible that she has a domicile of origin, possibly in New York, depending on what her dad's or mum's domicile was, depending on whether they were married or not at the time. Now, it's always good to check that, because very often you will find mum and dad might have moved around. It's not uncommon for parents to be in the diplomatic or service, or working abroad, or having started off in a completely different jurisdiction, moved to the US for work purposes and just happened to be in New York at the time Claire was born. So it's definitely worth following that up. But let's, for the sake of argument, say that Claire has a domicile of origin in New York. Now, I deliberately say New York as well, not the US. Under our rules, we are looking at specific jurisdictions, and because the US is a federal system, we have to look at each individual state, which of course makes the whole thing slightly more complicated, but again, it is important to bear that in mind. Peter was born in the UK. Again, we need to double check what position his parents were in, but let's just say for a moment that his parents were UK citizens, have always lived here. It is therefore highly likely that Peter also has a domicile of origin here in the UK. He moved to New York in 2000. There's a question mark over whether he might at that stage have said, actually, no, I'm intending to make my home in New York. I'm not intending to go back to the UK at this point of my life or going forward. He might have acquired a domicile of choice. He might not. Possibly not, given the time scale, but it is a possibility that we need to think about. When they moved back to the UK in 2013, that's the point where we start running into some more interesting possibilities. So Claire at that stage will retain her domicile of origin until she has acquired a domicile of choice. Now, whether or not she is intending to remain in the UK permanently or indefinitely going forward remains to be seen. We don't really have enough information here. That would need to be tested, but she might have done. Peter, on the other hand, if he has a UK domicile of origin, will be classed as a formally domiciled resident. And so his domicile of origin will kick back in. And that's going to be quite important when we look at some of the estate planning options, which we'll come on to a little bit later. But it's important to bear that one in mind as well. So there are, I think, a number of issues. You'll see at the bottom of the slide here that, as is often the case, we find that people in the US will pick up as part of their estate planning what's well known as revocable grantor trusts. In the US, the general view, if you have a chat with estate planners, is that probate is time-consuming, costly, a nightmare, and a thing to be avoided at all costs. I have a little bit of sympathy with that. Obviously, we have probate here in the UK, and it's not as fast these days as one would like, but it's not that bad if you get your act together and your ducks in a row. In my experience, the same could be said that's true in the US. There are a couple of states out there where it really is time-consuming and expensive, California being one, New York I would say is at the worst end of the scale. But equally, there are states where it's really not that much bigger deal. But in any event, typically the advice is, no, you should set up a US revocable grant or trust. Under the terms of this, you will both be the trustees. You have complete freedom to do what you like with the assets when they go in. It's all tax transparent from a US perspective, but it means that on your death, either further trusts kick in or assets get distributed outright to your beneficiaries, depending on what you want to do. But either way, you can avoid probate. That works very well if you are US based. There are potentially problems with it where we're dealing with UK domiciled clients because of the inheritance tax issues and because of how the UK will look at these types of trusts and the risks involved with them. So we spend a lot of time looking at these types of trusts for clients. Broadly, if these are drafted properly, then very often we can take a view that they might be Baer trusts. So they're not substantive settlements per se, like the US. They are transparent for tax purposes. It's as if the assets are owned by Peter and Claire beneficially outright. They're subject to tax on income and gains in the usual way. The problem at our end is where, for example, Peter in later life or Claire lose capacity and don't have an ability to revoke these trusts, because at that stage, we've then got to worry about whether they become substantive settlements for UK tax purposes. And if they're regarded as a UK substantive settlement, then the question of domicile is really quite a crucial one. If as a UK domiciled person, I put money into a trust, I can put up to £325,000 in, or I can put in assets which are subject to some sort of relief. But anything above that is going to be immediately chargeable at 20%. And if I die within 7 years, a further 20% is charged on top of that. The trusts themselves are then subject to 10-year anniversary charges at 6% and exit charges on distributions of capital of up to 6%, depending where in that 10-year cycle a distribution of capital is made. And I say capital, not income, and that's a key point. So the danger here is that if at the point where Peter and Claire create a settlement or are deemed to have a settlement created in the UK, there are potential tax charges here. And if all their assets that they've acquired over the years are stuck in this trust, then potentially there's a lifetime tax charge they're not necessarily going to want. The danger then is that if Peter lost capacity or Claire lost capacity, that is a risk. Equally, on death, it may well be that under the terms of the trust, there will be provisions in there that basically says the survivor of Peter and Claire will benefit from the assets. Now, one would hope here in the UK that you would get the spousal exemption, again, assuming that it's there in full and either Peter and Claire at that stage are both domiciled in the UK or not domiciled in the UK, and we'd come back to that. But there is a risk here that the trust is treated as a lifetime trust that was not created via a testamentary document per se from a UK perspective. And so if, for example, as is often the case, the surviving spouse is given rights to income and capital and so on, that's taken away, that's there. It will not be treated as an immediate post-death interest, which is how we try and structure trusts created under wills here in the UK, so that we get the full spousal exemption. So there are potential issues there as well. Now, I think there's a concession that HMRC apply on some of these things, but frankly, we are living in ever more uncertain times, and I'm not sure I would necessarily want to rely on such concessions these days if I could avoid it. So the trust is an issue. The other thing to bear in mind is that typically, as is the case here, the individuals creating the trust are also the trustees. Now, if they become resident here and a trust is created, a substantive trust is created, for tax purposes, the trust is deemed to be resident on the basis of the residency of the trustees. So if both trustees are UK resident, it will be a UK resident trust for UK tax purposes, which again can cause all sorts of issues, not only from a compliance perspective in filing and so on, but also in terms of then worrying about what the position is in the US and matching the two up between them. So that's one of the things that would need to be looked at fairly early on, and the risks assessed. Now, it may be that in some cases we see clients who are only in the UK for a short time and are going to be going back to the US in any event, and therefore the risks are much lower, and it may make more sense to keep the trust, or at least to defund it in the short term if we're really, dotting the I's and crossing the T's. But to keep it there because they could use it again when they go back to the States, because it's still perfectly good planning and may well still be appropriate from their perspectives at that point. But certainly for Peter and Claire, I would be slightly concerned here to keep that grantor trust in place, given the information we have about them. We'd also want to have a look then at UK wills on top. But anyway, so that's the first thing that we would need to have a look at.
Thanks for that introduction, James. We'll dig more into the deep darkness of trusts, I'm sure. But I want to kind of just go back slightly to one of the parts that you mentioned there, which I think is quite important, because both the US and the UK have a provision in estate planning or inheritance planning where a spouse can inherit or can receive assets from their partner without it triggering a charge on that first death, so enabling a spouse to receive significant assets without any consideration. Now, you mentioned there, which is very important, that actually if there's a difference in domicile or status for the two individuals, that's not always the case, is it? And actually, you could, in some circumstances, find that there's a charge just in passing assets from one to another.
Yeah, that's very true. I mean, if you have one spouse domiciled in the UK or deemed domiciled in the UK and the other one isn't, then any gifts from the UK domiciled spouse to the other on death will not get that full spouse exemption. It's limited to £325,000, which again is in the grand scheme of things quite stingy. But as you know, Nathan, it's not necessarily the end of the world, because let's say Peter died tomorrow and Claire had been claiming to be non-domiciled at that point. There's nothing preventing Claire electing to be treated as domiciled in the UK for tax purposes going forward. Now, that would then mean, and even if she did that after Peter's death, she could still do that and still get the full unlimited spousal exemption. However, as we all know, doing something like that has consequences, and one of the trade-offs, I suppose, would be that Claire needs to consider what that could mean more broadly in the long term, because not only is she then domiciled in terms of getting the spousal exemption, she's going to be domiciled thereafter from a UK perspective. So is it worth doing? It's definitely worth taking the advice and looking at the pros and cons at that stage. But you're quite right, you can end up in quite a pickle with tax to be paid at a point where you would be hoping there wouldn't be any.
Mm. Now, I know this isn't a kind of ongoing tax consideration or discussion here, but Brian, I guess kind of just reading through that immediately, I kind of look at, they've sold their property in the US, retained a portfolio of investments over there. That's something that needs to be considered at any point, not just when you're thinking about estate planning.
Absolutely, absolutely. There's big considerations that, again, like James pointed out, cleaning something up before you get over to the UK becomes a little bit easier than doing it once you're here in the UK, because anything in a portfolio outside of the UK that owns managed structures needs to meet HMRC guidelines. So if you have an investment portfolio in the States, it's going, and let's just say it owns the most popular ETF in the world, SPY, that is the S&P 500. That's not going to be HMRC compliant, and therefore will be taxed at the full rate, your earned income rate, instead of the lower 20%. If you were still in the United States, you could potentially clean that up at the low tax rates in the United States, and get it into a fully HMRC compliant portfolio. But once you're here in the UK, you might have to wait it out, or hope that essentially you don't have to sell it before you pass on the problem to the next generation. So pre-planning is the key on helping on the portfolio design.
Yeah. Now, one of the questions that I often get from families like this who come to the UK is, hey, should I just bring our investment portfolio into the UK? James, now perhaps for Peter, there might not be much of a difference to him where the assets are held, but maybe for Claire, certainly when thinking about estate planning, is there a difference for her?
Well, there could be, depending what she wants to do. Let's roll back a step. If Claire's claiming to be non-domiciled here, then the starting point is that any assets she has outside the UK that are not situated in the UK will be outside the scope of UK inheritance tax. So if she's bringing them into the UK, she's immediately creating a UK IHT problem on the face of it. So it's definitely worth thinking about where those assets are going to be, purely from that perspective. But I guess there are practical considerations as well, Nathan. I mean, if you're going to be in the UK, you've got to fund your lifestyle here. You know, you may not want things in dollars. Obviously you can change accounts around and so on. But is it practical when looking at it in the round to have these assets offshore, particularly if they're moving to the UK permanently?
Mm. What else jumps out for you, Brian?
A lot of different questions come to mind. You came up with the word trust in there, and there's a couple children involved. So if we had, say, a Uniform Trust to Minors Act, an UTMA account for the children, would the UK consider that just like any other trust, or is it not problematic?
Whenever you have a trust, you've got to look at how the UK are going to treat it. And some of these trusts don't nicely fit into the sort of categories that we have in the UK. And so you've got to look at these things very, very carefully. So, for example, I look at a lot of revocable grantor trusts, and some of them, you know, are drafted in such a way that, I'm sorry, they are absolutely going to be regarded as settlements here. So I think the answer to your question, Brian, for those is I'd want to have a look at them very, very carefully, because I've yet to find these types of trusts, or indeed uniform trust that's drafted in the same way across the piece. We've got to look at it very, very carefully in each case. It's not a one size fits all, unfortunately.
Absolutely, it's a struggle at all times.
Always. I mean, the other interesting thing, I suppose, here, certainly from a planning and a UK angle, we know that they purchased a family home in the UK, which Claire and Peter jointly own. One of the things we see time and again between UK, US couples is property ownership. And when they come to sell that property, obviously in the UK, the position is straightforward because it's their primary residence. They will therefore get principal private residence relief on the sale, most likely, assuming there's not excess land over half a hectare, which could be arguable. But they won't. It means they won't have any capital gains tax. Now, obviously, in the US, principal private residence relief doesn't exist. Instead, there's an exemption on gains of, I believe, 250,000 to worry about. So for a lot of couples who have bought property in London where the market has done very, very well over the years, it could be that Claire's share of the gain is much higher than that allowance, in which case she could easily find herself with a US tax liability that she may not otherwise want. And so one bit of planning they might consider is to think about Claire using her US annual allowance to give Peter the equivalent share of the property according to value and of the beneficial interest each year, to use up that allowance, with the idea that when they come to sell, Claire's share of the property will only realise a gain that is within or below US allowance. And we see this quite a lot with couples doing that. But again, and we've touched on this before, the key here is planning and long-term thinking. And so the sooner you start thinking about that, the better.
And James, I'm just kind of noting here that Peter and Claire moved to the UK in 2013. So assuming that's when they kind of started their tax residence here. Now, if you're working on the basis that Claire is not UK domiciled, she's coming up to that 15-year time frame when she might become deemed domiciled. Can you kind of just explain that concept a little bit? What that might mean?
I didn't touch on it earlier, but the current UK rules to avoid those who manage to retain a non-UK domicile keeping those tax benefits forever and ever, the UK have rules that say once you've been resident in the UK for 15 out of the previous 20 tax years, you are deemed to be domiciled here, at which point you lose all the potential tax benefits you could otherwise get as a deemed domiciled person. So there is a window here for Claire to do some planning before that happens, and there are a number of things. But the most obvious and common that we see is looking at setting up an excluded property trust. So I mentioned a little bit earlier on trusts that the vast majority of trusts that are set up, with a couple of very small exemptions, but the vast majority fall under what's known as the relevant property regime. So you have that initial entry charge if you put in more than your nil rate band, or assets that aren't subject to inheritance tax under some other form of relief. 10-year anniversary charges, and then exit charges where distributions of capital are made. An excluded property trust gets you round all of that. It means that Claire could set up a trust. It could be onshore in the UK, or it could be offshore. It's fine. You can have excluded property trusts onshore as well. But the key is that it doesn't hold any UK situated assets, and that she does this and funds it before she becomes deemed domiciled. And here, particularly with the sort of US UK side, very often these are set up as US trusts because of some of the fairly nasty US tax rules that can arise for non-US trusts. But it doesn't have to be. It could be in another jurisdiction, classic, Channel Islands, Jersey, Guernsey, or somewhere out in the Caribbean, the usual suspects. But what that would mean is that Claire can benefit from it Peter can benefit, their children can benefit, and wider family, and it remains outside the UK inheritance tax net, thereby saving you that 40% saving, no 10-year anniversary charges, etc. That's a very broad synopsis. There are some wrinkles in there that we've got to bear in mind, and particularly around distributions out of that trust for income tax and capital gains tax purposes, and we'll come on to those a little bit later on in the next section. But certainly for Claire at the moment, she's got a window right now where she could do some of that planning, and I would suggest the sooner she looks at that, the better. That said, I think, Nathan, I'm sure we're all conscious of the fact that we're living in slightly uncertain times politically, and certainly Labour have made very clear that a lot of this non-dom planning is going to be abolished. Now, they have not made clear what their proposals are in the detail, and there's a lot of chatter around, well, does that mean that if you're non-dom, you're not going to be able to do any of this going forward, but our current structure is going to be grandfathered in? Are they going to put some other form of regime in place? Certainly, my own view is that this is quite a tricky area, and that we want to encourage people to come and live in the UK and spend their money here and invest here. And so getting rid of it completely would seem possibly a little too hard in the circumstances, bearing in mind the economic position we find ourselves in. So we're yet to see anything, but inevitably I have clients talking to me saying, do I do something now? Do I wait? What are the risks? And I think it very much depends on your own individual circumstances, your appetite for risk, and how close, for example, you might be to becoming deemed domiciled under current rules. Some clients are willing to take more of a punt on these things and hope that these things are going to be grandfathered in, but keeping things as flexible as they can so it could be unwound if needed. Others are a bit more risk averse. So I think it varies a bit, but you're quite right. It's something Peter and Claire ought to be having a think about.
Great, thank you. Well, should we move into the next slide here, where we start looking at some of the perhaps more challenging elements, James, with some of the positions that are in place.
So this is where when these sorts of facts come out and the clients have moved already to the UK, I heave something of a sigh, because we've already got ourselves potentially some problems. So we've got three issues here. One is that Claire is already a beneficiary of a US trust, which was created by her late grandfather, and has been receiving distributions from that trust since 2003. So let's deal with that one first before we move on to the other two. Well, from a UK perspective, up until the point Claire moved back, from a UK perspective, we really couldn't have cared less. There were US tax issues there to worry about, but from the UK side, we didn't really mind. The point Claire moves back and becomes a resident here, from a UK perspective, what we have is a foreign trust, which a UK resident beneficiary is receiving a benefit. And there are a range of rules under UK tax law as to how distributions are to be treated from foreign trust to UK beneficiaries. Now, all being well, what will happen is that any capital distributions will need to be matched with the income that has not been taxed in the UK. So we look at the trust and we say, right, what income has been created or generated within the trust since it was first created? If it hasn't been taxed in the UK, it forms a pool. We do the same thing for what are known as offshore income gains, and the same thing again for ordinary gains. And there are a series of rules around matching, so that when a distribution is made, the value of that distribution is matched against these pools, and there are rules as to which pots you match against and in what order. But broadly, it's income first, offshore income gains, and then capital gains. Depending whether it's matched against the income or the gains, there is then a tax charge on the beneficiary to income tax or capital gains tax, and the rate of which will then depend broadly on their marginal rate. So it means several things. One, it means that Claire should have been reporting these things on her tax return since arriving in the UK. It means that the trustees will need to be employing somebody to work out what these pools look like and to keep them updated, and to provide Claire and her tax advisors with the updated pool numbers each and every time she receives a distribution, so that they can do the matching exercise and work out what Claire's tax position is going to be. In the vast majority of cases, when I look at these things, that hasn't happened, which means there's a bit of a tidy up exercise to do, but it's certainly something that both trustees and Claire need to get on top of as soon as possible. Looking at the other two, Claire's parents, they're reviewing their own estate planning. Frankly, this is an opportunity to save tax and put Claire in a position which I suspect her parents are hoping to put her in the first place, which has only been made more complicated by her moving to the UK. So again, it could be that by putting their assets, or Claire's share of their assets on their deaths, into a trust, for example, they could keep that out of the UK inheritance tax net and have it administered for Claire's benefit very advantageously. Equally, if they get it wrong, they could cause a big headache. I can think of one client very recently who was going to receive a share of a property in Florida, and was effectively given a life interest, or what would have been deemed to be a life interest for UK purposes. That was going to cause all sorts of issues for him from a tax perspective going forward, and actually trying to say to mum and dad, you're much better off leaving the asset outright to him rather than mucking around with a trust. In that case, would have been a much better idea. But that's something to bear in mind again when looking at these things. The third point is the most problematic. So we've got Peter, who's created an irrevocable, what let's call it a completed gift US discretionary trust while he was in New York, thinking, we've just had a child, we need to put some money aside. This seems like a very good idea. Let's go and get on with it. Both he and Claire are trustees. We've already said on moving to the UK, the tax status of the trust is determined by the residency status of the trustees. And so the first thing to point out is that trust is now a UK situated trust for UK tax purposes. So question mark, have they been filing to date? Chances are probably not. That's the first problem. The second thing then goes back to the point about Peter's domicile. So I mentioned earlier that because he has a domicile of origin here, he was born in the UK, he will be treated as a formally domiciled resident. That means that he has lost at this stage any benefits that other non-domiciled persons would have. It means that trust, although it may have been created at a time where he could have argued that actually I'm not domiciled in the UK, I may have acquired a domicile of choice at that point in time when I created it, it doesn't matter. That's now become a trust that's going to be subject to the relevant property regime. So we're back to 10-year charges and exit charges and so on. So he has lost the benefits there. And that's obviously come in from a change in the rules back in 2017, but something that keeps tripping people up, particularly British expats coming back to the UK who've picked up structures and other things abroad, which may well have worked very, very well when they were there, but unfortunately are not going to work quite so well here. So that is something that will need to be looked at going forward and assessed whether it's worth keeping it in place. But again, very much depends on what Peter and Claire are intending to do and the wider family position and intentions and so on.
And James, kind of just putting onto a practicality point, that first one there where you spoke about Claire's receiving these distributions out of the trust, she's going to get effectively taxed on the profits that she's receiving out of it. Now, the US trust, might not see, well, there's nothing we can really do about that. But I guess there is something that they could do about it from an investment point of view by making sure that holdings within inside it are holding UK kind of tax efficient investments, couldn't they? So you mentioned obviously the ordering being income, offshore income gains, and then gains with a bit of careful investment management by Brian, for example. Perhaps they could avoid, creating the offshore income gains with higher taxation and have kind of regular capital gains that would be taxed at a lower rate.
Absolutely, and it's crucial really to once you're aware of the problem to have that reviewed very, very carefully and sit down with whoever is doing that investment management. And if you can find a way of cutting out income, if you will, a lot depends, I suppose, Nathan, as well on what the size of those pools will be, because this trust, I mean, we don't know from this, but if this trust has been going for many, many, many years, there could be quite a significant pool there to work through. And frankly, you're never going to deplete the different pools long enough to get just down to gains. So it is going to be a case of looking at it. But yes, you're quite right. It could be that it's relatively new. It could be that the way the investment strategy has gone, there is very little there, and it could be managed round so that it is only generating gains, but that's something that would need to be looked at very, very carefully.
Yeah, indeed. I'm conscious of time here. We've managed to ask a few questions as we've gone along. But if anybody does have any last minute questions here in the last few minutes, please do put them through on the Q&A. I guess, Brian, before we start wrapping up, we did promise to give some top tips before the year end here, and perhaps you can kind of just do a whistle stop tour of the kind of things you're thinking, I guess, from portfolio points of view of what people should do before the end of December.
Absolutely, it's that time of year that you got to make sure that you get ready for the new year and clean up things so that your taxes are as easy as possible. Naturally, the first and foremost, we've had a couple good days in the market, but there's a lot of tax harvesting opportunities in portfolios. And if you have any losses inside of your portfolio, you might be able to take those losses to offset against future gains. You also want to make sure that you look at any contributions that you might make to a retirement account. One thing that we haven't talked too much about is that pensions here in the UK are not eligible for IHT tax, correct, James?
Yeah.
So
structured properly. Yeah.
So naturally, that becomes an IHT strategy, avoidance strategy to maximize your pension, and there was a nice increase up to £60,000, and without the lifetime allowance, all things that we've talked about on other webinars. So sorry to go through them so quickly. It might be an actual opportunity to max out your pension. Another strategy that can be used is you can go back the last 3 years if you haven't maximized your pension to make those contributions. So look at those strategies of using some of those retirement accounts. Now, question there on James, actually, somebody pre-submitted this. U.S. retirement accounts, do they get that pension allowance for IHT?
The multi-million-dollar question. That's a very interesting one. And I've asked this question from a number of different tax accountants here in the UK on several occasions, and I get two different answers about 50% of the time. Some of them will say, yes, of course, You will get that treatment here in the UK. They're basically QNUPs. That's fine. It's not a problem at all. Others say, well, there's a bit of concern around them as to how they're actually, again, like trusts, how are they actually drafted and put together and so on. And no, we don't think they necessarily will get IHT relief. I would always err on the side of caution. Far better to work on the basis they're going to be taxed one way or another. Frankly, foreign pensions have always been an issue from the revenue side, which has always caused a bit of a thorn. You look at the way the CUROP rules and all the other things have worked over the years. Approach with caution. So I would plan for the worst and hope for the best on this.
Okay, I threw a hard one there right at the end. So since we don't have that much more time, let me throw a nice easy one. There's 92 different exemptions that we can take here in the UK for an estate tax purpose. What is the most exotic, craziest one in your books there, James?
Ooh.
An opinion question, so there's no wrong answer.
The craziest. That's an interesting one.
Nathan, you can have one too.
To be honest, Brian, that they're all fairly seriously boring at the best of times. We are talking about tax after all. I'm racking my brains.
I love the fact that you can buy a pub by buying Young's Pub, and because it's AIM listed, you get an AIHT exemption for that. Or that if you marry a monarch, you get an exemption for that.
I was going to say that the monarch point is an interesting one. I think in one of the more interesting exemptions actually is if you own a very large historic house, or you own chattels that are, I don't know, the painting by a famous artist or whatever, that have preeminent historical significance. You can say to the revenue, actually, no, if you let me off the inheritance tax and I make these available to the general public to view and come and see for at least 30 days a year, and some of those do have to be on bank holiday weekends, you can't pick and choose, and promise to look after them and give undertakings, then no, I won't have to pay any inheritance tax at all. There are a lot of landed estates here in the UK, for example, who death duties tore through in the early part of the 20th century, many of whom now are still on their feet because of that exemption. And it's a slightly odd one, but we still do see it.
Yeah, that's an interesting one for sure. Yeah. I'll remember that when I'm next doing my historic house tour somewhere in Kent.
Absolutely. I mean, I think Arundel Castle, for example, is still privately owned, but I'm the understanding I had from the guide when they were taking us round was that effectively this is exactly the setup that's there and why it is still owned as it is by is it the Duke of Norfolk, I think, from memory. But yeah, there are a few of those still kicking around the place.
You don't even take a day off on your days off, James.
No, I like the history, and it was thrown in at the end, to which I thought,
Okay, I lied. I've got one more question for you, James, and it's, again, just an opinion question. Right now, IHT only makes up, inheritance tax only makes up 1.7% of the government's revenue. There's been some rumors that before the next election, they might tear up the inheritance tax.
Well, they've said they will put it in their manifesto and consider tearing up inheritance tax. If we look at the fine print, I think it highly unlikely. We've got a big black hole in the public finances. Inheritance tax take has increased over the years. Ideologically, it plays well. And there are lots of people who think inheritance tax is genuinely unfair because you're effectively paying tax yet again on income and gains that you've already been taxed on. I think that certainly the inheritance tax legislation and some of the reliefs that are out there, particularly business relief and agricultural property relief, need properly looking at again and reforming. But I can't see the Tories doing that. And certainly the noises coming from the Chancellor. It'll be interesting to see if there are any tax deductions at all. But complete abolition, I'm not going to hold my breath.
Had to ask the question.
Indeed. Well, thank you very much. I think we're probably out of time.
Thank you, James.
Brilliant.
Thank you, Nate.
Thank you both.